Abhinav, we are ready to go. With your permission, sir.
Yes, please.
Good evening, everyone. I'm Abhinav Shukla, Senior Content Editor at Jus Corpus Law Journal, and the host for today's session. I, on behalf of the whole team of Jus Corpus, welcome our guest speaker, eminent advocate, Mr. Muneeb Rashid Malik. We welcome you, sir. I also welcome all the participants in today's session on the Mediation Act 2023, its scope and analysis. Before we delve into today's discussion, let me provide a brief introduction of Jus Corpus Law Journal and the eminent guest speaker of the day. Jus Corpus is an edtech platform established in 2020, comprising a collection of legal professionals. The platform aims to consolidate various aspects and chains of law under a single umbrella. With an impressive reach averaging 600,000 clicks per month on its website, Jus Corpus was inspired by the growing needs of law students. As parts of its initiatives, Jus Corpus has introduced an interdisciplinary journal known as the Jus Corpus Law Journal. Now, turning our attention to today's focal point, we are privileged to have Mr. Advocate Muneeb Rashid Malik as our esteemed guest speaker. Sir is an advocate practicing in the Honorable Supreme Court of India. He regularly appears before the Supreme Court of India, High Court of Delhi, Common High Court for Jammu and Kashmir and Ladakh, National Company Law Appellate Tribunal, NCRDC, National Company Law Tribunals in matters related to constitutional law, criminal law, civil law, arbitration law, consumer law, insolvency law, and etc. Sir has delivered lectures on various law subjects in law schools across the country. Sir has more than 100 publications to his credit, and he always writes on topical issues. Sir has worked as an advocate at Luthra and Luthra Law Offices India. Sir has also attended many international and national legal conferences and seminars. Sir has adjudicated numerous international and national moot court competitions, client counseling competitions, negotiation competitions, mediation competitions, and trial advocacy competitions, to mention some. Sir is also an advisory board member of Jus Corpus. Without further ado, I would like to hand over the floor to Sir for insights into the Mediation Act 2023, its scope and analysis. Over to you, sir.
Thank you, Abhinav, for this wonderful introduction. So the topic which has been given to me is very important because the Mediation Act was brought before the Parliament in this year. In August 2023, it was passed by the Rajya Sabha, the mediation bill. And in the same month, it was passed by the Lok Sabha. And also, it received the assent of the President in September. Now, when it will come into force, some provisions have already come into force. The dates will be notified by the central government, and the dates may vary for different provisions. Before adverting to the key provisions of the Mediation Act, let us go into the historical background of mediation in the country. Before mediation came into the statute books of the country, we used to have mediation in the form of panchayats. We used to have settlements in the form of a group of people in a village who used to settle a matter in a town, in a village. And then there was no court interference. There was no legislative interference. A petty issue came into being. It was settled by the elders of the family or of the village or of the panchayat. So it dates back to 1889, when the Arbitration Act was passed by the British India. But it was restricted to 3 towns. That was the presidency towns: Bombay, Madras, and Calcutta. And it did not extend to the whole of India. So that was the first dispute resolution legislation. Then we had 1908 Civil Procedure Code Section 89, which talks about arbitration, mediation, conciliation, and lok adalats. That was in the statute book since 1908, when CPC was promulgated and it came into effect. So Section 89, 1908 section, that was the power with the courts. Then we had the Arbitration Act of 1940. But that was more resembling to the English Arbitration Act. Then we had the Arbitration Act of 1996, which is the current Arbitration Act. It has been amended in 2015, 19, and also in 21 and 22. For mediation, we did not have an act. Mediation, we had the Section 89, power of the court to refer parties to mediation. That was inherent power with the courts, with the civil courts, not with the criminal courts. And in 2021, the mediation bill was tabled in the parliament. But due to some discussions by the standing committee, it got delayed to 2023. And finally, in 2023, we have the Mediation Act. Now, what is mediation? Mediation is assisted form of negotiation. Two people are fighting for a property dispute. Now, if they settle it between themselves, that will be negotiation. That will not be mediation. But if a third person comes and he settles the issue of those two persons who are fighting among themselves, that person will be mediating the issue. His decision will not be binding. His decision will be suggestive. And it will have no binding on what the parties will want to decide at the end. So the Mediation Act talks about fundamental changes in the alternate dispute resolution mechanism. Number one is you will be having a settlement of mediation which will be enforceable like a decree of a civil court. So that is the first fundamental change. So parties have entered into a settlement, have entered into a mediation. Now the parties, the decision which has been finalized between the parties, that will be finalized by way of a settlement agreement, which will have the weight of a decree of a civil court, which can be executed. I will come and discuss the loopholes of the Act, but first I will discuss the provisions of the Act. They're very important. Then I will answer your queries also. Now, Mediation Act 2023 talks about settlement agreement which will have the force of a decree of a civil court. But the question is, will this civil court, decree of a civil court, be applicable to matters which are criminal in nature? Not all disputes can be settled through mediation. Can murder be settled through mediation? Criminal matters cannot be settled through mediation. Corruption matters. Then heinous offenses. So this Act also talks about those offenses which cannot be mediated between the parties. Now, we'll stop it here and we'll go to Consumer Protection Act. That has the provision of this 2019 Consumer Protection Act has the provision of mediation. Commercial Courts Act 2015, Section 12A, has the provision of pre-institution mediation. So parties, before instituting a commercial suit, have to go to mediation unless they show there's an urgent relief to the court. This reminds me of the judgment of Justice Joseph in Patel Engineering versus Raheja Builders, when he said Section 12 of pre-institution mediation is mandatory in nature. So look at the interpretation of the court. Court said this is mandatory in nature. So this is for the burgeoning and blooming of mediation in India. So the court also figured out some loopholes with regard to mediation in the country. Number one is, we don't have the required infrastructure of mediation. We have less mediators in the country. We don't have a dedicated bar of mediation. Lawyers, we are not dedicated, like a bunch of lawyers are not dedicated towards mediation. That mindset is missing. Now we come to the matrimonial disputes. Courts always have the power to refer parties to mediation in matrimonial disputes also. So that power will never be taken away by the legislature, because that is the inherent power. That is Section 89 of CPC, because the legislature has given the power. Now the Mediation Act talks about Mediation Council of India. We did not have a Mediation Council of India before. Now the Mediation Council of India will be responsible for choosing the mediators, for choosing how much duration these mediators will function, for choosing which matters will go to mediation. So this will be institutional mediation. So we have court annexed mediation. We have Delhi High Court Mediation Center. We have the Punjab and Haryana Mediation Center, High Court Mediation Center. That is court annexed. But this is institutional mediation. So an institution of mediation is providing facility of mediation. So this is another change which has been brought by the Act. Institutionalization of mediation. Then we have community mediation. Now, community mediation will not be binding. So this is a catch. Community mediation will not be enforceable like a decree of a civil court. Community mediation will be held in a village or in a town by a community. So for that, a person has to write an application to the Legal Service Authority, constituted under the Legal Services Authorities Act 1987. And if that authority is missing, a person has to write to the DM, district magistrate of that particular district. And then the panel of 3 mediators will be selected from the community itself. And that mediation will happen in the town or the village in which the community is based. That is one more interesting and a very important change brought by this Act. Then we have online mediation. This is another wonderful feature of this Act. It is focusing on technology as well, whether we have the infrastructure or not, but online mediation is also being encouraged by the Act itself. So if at any stage parties think that this mediation can happen through virtual mode, with the consent of the parties, the mediator can decide that these proceedings, mediation proceedings, should be conducted through virtual. That is online mediation. Now, questions arise: what will be the duration of this mediation? It cannot be forever. It cannot be for 2 years, 3 years, 4 years, just like court. It is mediation. It is not the same way we go in courts of law, and the matters also take time. There is docket explosion in courts. The Act says 180 days. Within 180 days, mediation proceedings have to be completed, which are extendable by another 180 days. but with the consent of both the parties. So that is the duration of the mediation proceedings which has been enshrined by the Act. Now the question is, what matters will go to mediation? Suppose there is a property dispute. That will simply go to mediation. There is a matrimonial dispute. That will go into mediation. There are petty offenses. For example, Section 138 of the Negotiable Instruments Act. That can also go into mediation. I have tackled those matters in mediation. Then there are various other matters, but not heinous offenses, not criminal matters, which have a bearing on the society as a whole. There we cannot have POCSO matters. We cannot have mediation with such offenders, because that is crime against the state. Now, before the passing of the Act, there was a term that mediation will be mandatory before the institution of civil suits and commercial suits. But the Parliament Standing Committee and the Cabinet changed the word shall to may, making it voluntary. Mediation is a voluntary process now. It is otherwise a voluntary, but this Act had made it mandatory. But now it has again made it voluntary. Now the question is whether this step of making it mandatory would have proven beneficial for reducing the docket explosion of courts. Or number two, whether this step of changing it to may is a good step, because mediation is always voluntary. This is some queries which we should pose to ourselves. These are interesting queries. Now, our Mediation Act is not premised on any foreign law. And if a mediation happens outside India, the Act does not talk about whether that will be enforceable like a decree of a civil court in India. And the Act has given vast powers to the Mediation Council of India as well with regard to referring of disputes to mediators, but there is no criteria for selection of mediators, what a mediator should have, the qualification of mediators. So the Act is silent on that. The actual qualification, whether a person should be a lawyer, whether a person should have minimum 5 to 6 years of experience, what is the criteria, that is missing. So an interesting case came to me. That was, parties were entangled and embroiled in a legal tangle. So the case was the 138 Negotiable Instruments Act. So the parties, one of the parties, the complainant, he filed a criminal complaint under Section 138 of the Negotiable Instruments Act. Complaint was admitted. Summons were issued against the accused. And on the next date of hearing, the accused was present. He said, I am willing to settle the matter. The matter went to a court of law, to this mediation, court annex mediation center. And there he said, I am not interested to settle the matter through mediation. Now, this is a very interesting story. First, in court, he said, I am willing to settle the matter through mediation. Now, in mediation center, he says, I am not willing to settle the matter through mediation. The mediator sends it back to the court. But court obviously told the accused, you said one thing here and now you are saying another thing there. What is this? He said, no, I'm now willing to settle it. I can hand over the check amount to you. Court said this is the final opportunity. Otherwise, now I will hear the case on merits. He went to, again they went to mediation center for settling, because this was the amount was huge in question. There he started settling. First, he did not appear in the mediation proceedings for 2 or 3 dates. He said, I am ill. And then when he appeared on the 4th occasion, the mediator told him, how do you want to settle the issue? He said, I'll be paying I'll be paying in installments on the first of every month, such and such amounts. So there was a settlement agreement, and then that was shown to the court and the matter was settled. But before the 138 matter was filed, the complainant had also filed a 420 case. That is a cheating case, a criminal complaint on cheating as well. That was also admitted. And then FIR was pending against the accused. He then contacted the complainant that I will not give you the rest of the amount, which was pending after the settlement. He said, if you don't, if I'm going for the quashing of the FIR before the High Court, and you don't have to delay the proceedings. The complainant said, I will not delay the proceedings. You come to High Court. For quashing, I will have no issue because we are settling the matter at hand. And then FIR was also quashed. Now this story I'm narrating is because of mediation. Now, if mediation would not have happened in the case at hand, which I am stating to you, then the matter would have, there were 3 parallel proceedings. He was being entangled in 138 proceeding also. He was being entangled in criminal complaint also under this 420. And then he was being entangled in this breach of trust, criminal breach of trust as well, that is in the 420 proceeding one. So for the recovery of money, there was a civil suit also filed. So there were 3 parallel proceedings. Now mediation changed the course. For 3 proceedings, there was only 1 mediation proceeding, and mediation helped the parties to settle the issue at hand. Now the Mediation Act has its hits and misses. There's no doubt about it. But this is a step in the right direction. Now the settlement agreement having the binding force of a court of a civil decree, like there's a decree of a civil court that will be executed in the form of a civil decree. So you see, now mediation is getting burgeoned and flourishing effect in India. Mediation has also become the order of the day. Mediation has happened in so many of the landmark disputes. Mediation has helped parties to solve their disputes amicably. So that is the Mediation Projects Committee, the Mediation Committee of India of the Supreme Court, along with the mediation committees of the high courts. They started this mediation court annex mediation centers. The basic objective was to solve petty issues and the issues which can be mediated in court annex mediation centers. For example, in Delhi, we have the Delhi High Court Mediation Center. In Patiala House District Court, we have a mediation center. We have Supreme Court Mediation Center. We have mediation centers in courts also. So this was before the advent of the Mediation Act 2023. So it is not that after the coming of the Act of 2023, mediation court annex mediation centers were established in the country. They were always there. Now, under the Commercial Courts Act, the landmark judgment of Justice Joseph, which I was talking about in Patel Engineering versus Raheja Builders, he has talked about why mediation is important. And especially the loopholes we have in the country with regard to burgeoning. So you have to ask yourself whether we have the required infrastructure. Number 2, whether we have the required mediators. Number 3, whether we have the mindset of mediation. Number 4, whether we have a dedicated bar of mediation, whether the members are interested to solve, the members of the bar are interested to tell their clients to solve their issues through mediation. So these queries you have to ask yourself before discussing mediation and then settling the issues at hand. This is the mindset has to come to us. Whether an issue, a petty issue, can be solved through mediation. Now I'll tell you an example. The Mediation Act 2023 has been passed by the Parliament. It has received the assent of the President. It has also amended various legislations to streamline the Act's basic objective. But the mindset is required. Now, this is voluntary. This is not mandatory. But that the mindset of solving the issues through mediation is with the parties. Parties have to accept that courts are reeling under docket explosion. Courts are flooded with cases. Judges are less, cases are more. Every day cases are being filed. So you have to accept the fact that docket explosion is there in courts. So whether we are ready to solve our issues through mediation, whether our parties are ready to solve our issues through mediation. If we tell a party that you have a property dispute, we will file a civil suit and it will be solved in a matter of months, then we are lying. We are misleading the party. It will not be solved. It will take a lot of time. How many of us will tell the clients that this issue will be solved through mediation? I'm talking about issues which can be sorted and solved through mediation. Suppose there's a matrimonial issue between two parties. And the issue is not so big. Issue is a minor fight, a minor misunderstanding, a minor miscommunication. And the parties have filed a divorce on the basis of the grounds which are enshrined in the various acts. For example, Hindu Marriage Act. But if one of the parties is ready for mediation, can it save the relationship? If there is no irretrievable breakdown of marriage, it is the mediation that can save relationships as well. It has to be a win-win situation for both the parties. It is not that one thing I will say one thing and the other will say another thing. I will not accept that another thing, but I will want him to accept my thing. That is not mediation. You have to compromise on a thing. He will compromise on a thing. The other party will compromise on one thing. You have to compromise. So it has to be a win-win situation. You don't have to, if you want to fight it out, then court of law is the best place for you. Then mediation is not for you. You fight it out before a court of law. If you are on a mediation table for fighting, to burst your anger out, then mediation is not for you. Now, the role of a mediator is important. The parties come, and this has been mentioned in the Act as well. Firstly, the mediator has to be impartial. If he is not impartial, then he will not be able to suggest solutions. He has to communicate to the parties and tell the parties what are the solutions available. A petty issue, a civil dispute, a commercial dispute, a matrimonial dispute. He has to understand the problem and offer a solution. He is not a judge. He will offer his solution to the parties, which can be accepted or not accepted by the parties. And then he will formulate a settlement agreement. Now, mediator's role is very important. He has to be free from biases. He has to be impartial, independent. He has to know the intricacies of life and the nature of the fights. And he has to ask relevant queries to the parties. He has to try to offer good solutions. For example, he has to ask the queries which have led to the fight at hand, so that he understands. And then he has to ask for the views of both the parties. And then he has to offer a solution. He has to listen to the solution of the parties also, because the parties also have a solution sometimes. So it is not only the parties who have a role in mediation, it is the mediator as well, who has a wonderful role to play. And not only the mediator, when matters are referred to mediation, it is the advocate also who has a role to play. It is not only the parties who will play a role, it is the advocate also who has to play a role, who is with the party. That advocate has to tell the party that this is a good solution or this is a bad solution. Let's look at it at this way, but with the objective of settling the matter at hand, not to waste the time of the mediator and then going back to the court of law. So not only the mediator, not only the parties, but also advocates have a role to play in mediation. And mediation is not only about curbing the pending cases in India. It is about developing a mindset. It is about solving various issues which the courts will solve, but which can also be solved through mediation, petty issues, or issues where mediation can help. Talking can help. Parties, for example, in negotiation, only the parties have to talk to each other. But in mediation, there is a situation when parties are not willing to talk to the other party in negotiation. When a mediator steps in, they talk to the other party through that mediator. And this is another aspect of the Mediation Act. That is why the Mediation Act has been enacted, to encourage mediation in the country, especially institutionalization of mediation, community mediation, online mediation. As a community, so we have been this Mr. Pandey. We have been joined by students from across the country. So students also have a role in community mediation. Why can't they have a role in community mediation? They can have a role in community mediation. For example, in your college, any fight has happened between two groups, two college, there are some like friend circle with another friend circle. There's a fight. And you can be a mediator. It is not only about matrimony, it is about a normal fight also. In a college, if there is a scuffle between two people, you can be a mediator. You are the future lawyers of the country. You are the future of the country. You have to develop this mindset that I am there to mediate the issue of my client. If you take him to a court of law, he will be there for 10 years, 15 years. Because his mindset will not be developed. You are the one who will tell him that what the Mediation Act talks about. He will not understand as a layman. Client will tell you only the facts. He will not tell you the law. He will not tell you the law. For law, you are there. For law, lawyers have an important role to play. Mediation Act has come into effect. Some of the provisions have come into effect, not all the provisions, but it is a legislation as on date. But as lawyers, we have to accept the legislation in its letter and spirit. Very important is community mediation. It is not enforceable in a court of law. Institutional mediation is enforceable. Court annex mediation is enforceable in like a degree of a civil court. Community mediation is not enforceable because there is no settlement agreement. Agreement is not there. It is an oral agreement. Just like I said, a fight in college, a fight in your neighborhood. That is why there is community mediation. And offenses of heinous nature cannot be mediated. That is why there is a section in the Mediation Act, provision in the Mediation Act, which says which offenses cannot be mediated upon. These are heinous offenses. Can a POXO matter be mediated upon? That will be travesty of justice. Can this rape case be mediated upon? Can a murder case be mediated upon? So these are heinous offenses. Say, can a war against state be mediated upon? No. We have to look at the umbrella of such offenses. Those cannot be put into the arena of mediation. So mediation as a whole, a mindset has to be developed. Now, in this Mediation Act, we don't have the provision. For example, a matter is mediated between two parties. One party is from India, another party is from Australia, and this mediation has happened in Australia. Now, can this mediation settlement agreement, which has been formulated and prepared in Australia, can it be enforced like a decree of a civil court in India? The Act is silent about it. Act does not talk about international mediation settlement. This arbitration is not silent about it. Arbitration Act has the provision. But Mediation Act is silent about it. Mediation Act is also silent about the mediator's qualifications. So these things the central government must look at. Otherwise, it is a step in the right direction, as far as I believe. There are certain queries which I am posing to myself with regard to some nitty-gritties of mediation. For example, as I said in the starting, whether this voluntary nature of mediation, is it because of that the standing committee or the cabinet has changed the word from shall to may? Is it that? That is number one. Or was the first decision of shall, keeping the word shall, was it apt, or is the second one apt? So this is a query which I am asking to the audience. Whether the first word of every civil suit or a commercial suit going into mediation, mandatory requirement, whether that was important, that was a step in the right direction, or mediation being a voluntary step, whether that is important. So my query is whether this voluntary nature of mediation has to be balanced, or whether the word shall, which was first used, that was correct, or now the second, which as on date, the word may has been used instead of shall, whether that is correct. Only time will tell, and the readers, the audience can also answer this. And another thing is, with regard to court proceedings, many a times we see court proceedings are underway. And then suddenly after 6 or 10 months, parties are sent to mediation. Why can't these mediations happen before? Why do we have to wait for the courts to interfere? Why do we have to wait for the mediators to interfere? Especially the courts, when courts send it. So another issue in the country is the mindset is missing, and parties just want to fight it in courts of all the issues which can be sorted through mediation. So recently, a matter was pending since 3 to 4 years. It's a property dispute in Delhi High Court. After 4 years, now the parties are willing to settle the matter through mediation. Now you see, after 4 years, this could have been sorted through mediation at the threshold itself. But the mindset was not there. And it has nothing to do with the Mediation Act. Mediation Act is just streamlining the way mediation takes place in the country, will take place in the country. It is basically focusing on institutional mediation, community mediation, online mediation, and also the function of Mediation Council of India. Who will be a mediator? What will the disputes which will go to mediation? All these have been answered by the Act. But whether the mindset, that is not answered by the Act. That is a query which I am posing to you. Whether this mindset, what are the steps of developing a mindset of mediation in the country? ADR, Lok Adalats. And arbitration, we have an award which is passed. And do you think arbitration has lesser court interference? Every time we see a 34 being filed. Whether you have, do you think arbitration has lesser court interference? It was supposed to be an act which has less court interference, but do you think it has court interference of lesser nature? And what is the status of mediation in the country? Do you think matters are getting settled through mediation, or it is just we are sending it to mediation for the sake of it, with no objective in our mind? So Section 2 of the Mediation Act talks about the definitions, and it says who a mediator should be and what his role is. But it does not talk about the qualification of a mediator. Now, a mediator, as far as I am concerned, can be anyone. It is not necessary a lawyer should be a mediator. A judge should be a mediator. He can be anyone. He can be an elder person also. He might not have read enough. He might be a layman. But he understands life and nitty-gritties of life so much that he can solve the issues of the parties. So he can give his solution. Technicality, lawyers may go into technicalities. Judges may go into technicality. But a layman, he might not be educated. Whether that is the reason why qualifications are missing in the act, that is another query which I pose to you, to the audience. Whether there should be a mediation, this qualification for a mediator, or whether there should be no qualification for a mediator, because mediation is a party-centric, voluntary dispute resolution process. This is assisted negotiation. This is not negotiation, but assisted negotiation. So mediation, whether we should have qualifications for a mediator or not. Or do you think a benchmark should be there, experienced people should be there, or a person of 30 years of age, will he be a better mediator than a person of 50 years of age? That is what I'm asking. So a mediator's qualification, whether that is necessary, but his qualities are necessary. He must be impartial. If a mediator's bias comes into effect, then he cannot offer a solution. So Mediation Act as a whole is a welcome step. It is basically, if you read the preamble of the Act, it's an institutionalization of mediation and community mediation and online mediation. And also the enforcement of a settlement agreement has been given the weightage of an enforcement of a decree of a civil court. So these things are the highlights of the Mediation Act. And I also talked about, briefly I've talked because I don't have much time at hand. Briefly I've talked about the history and the highlights of the Act and the problems of mediation in the country and the problems of the Act as well. So briefly, I have tried to cover it because of the paucity of time. Because if I do it section-wise, then it will take a lot of time because there are many sections. But I've given you the fulcrum of all these aspects, the historical background and the Act and the problems and the loopholes. But a step in the right direction, I must say. And for the burgeoning of mediation in the country, I think the central government must notify the provisions so that they are used by the people of the country. This will also reduce docket explosion. This will also reduce burden of courts. This will also, in fact, create a mindset of mediation. And also, this will strengthen the ease of access to justice. And parties will be, some parties are not able to go to courts of law. And they say, I'm not able to get justice. I have a civil dispute. But if the issue gets sorted by community mediation, that power is coming from a statute. If a community mediator, that is a panel of 3, if he sorts the issue out or mediates the issue, he is garnering those powers from the act itself. So it will also increase access to justice. It will also help in more burgeoning of mediators in the country. More people will come forward. Not only lawyers or judges, but common persons also. Common people who know the nitty-gritties of life. Elderly people. This is what happened in the previous days, in the old days, ancient time. There was no court or there was no tribunal. It was the people who sorted among themselves all the issues. And it is also important that mediators have the required infrastructural facilities. For example, if parties are referred to mediation, and mediator should have a place to sit, there should be a confidential room, there should be a place to sit, he should have a junior law clerk as well, who will help him in drafting a settlement agreement. He should have the facilities if he is joining through virtual mode. He should be able to join through his computer or laptop. That infrastructure has to be given by the state. So that is why this act talks about online mediation as well. Because you know, the COVID pandemic, when it struck, we were caught off guard. And there was no technological advancement at that stage. Like there was technological advancement, but we were not knowing how to use it. So that is how virtual courts came into effect. That is why online mediation has been given importance. Suppose a party is in India, another party is in Australia, and mediator is in India. They cannot connect two parties. The mediator and one of the parties can meet at a place, but what about the party who's abroad? So that is through online mode, through video conferencing facilities, that party can join the mediation proceedings. That is why online mediation is also a very important part. This is another technological advancement which has been, in fact, taken care by the legislature. And then there are various aspects to mediation as a whole. Which matters now? People often tell lawyers which matters should be mediated and why are criminal matters not mediated. They cannot be. How can a person who has murdered another person, can you negotiate with that person? You cannot. Can you draft a settlement agreement with that person? You cannot, because he has committed an offense against the state. It is only a bunch of matters which will go into mediation. That is why I am discussing this. Not all matters will go to mediation, but a bunch of matters. Now, there are parallel proceedings. In a civil matter also, there are parallel proceedings. To avoid that, a mediator has a role to play and the parties have a role to play. And they are the ones who will decide whether we should go to courts or not. Whether we want the matter to be settled through mediation or not. So that is very important. You, Mr. Pandit, do let me know when I have to stop. So another issue is with regard to the Consumer Protection Act. Whether the Consumer Protection Act, which has given the power to the parties to settle their issues through mediation. Now, this is Consumer Protection Act of 2019, and e-commerce was also made part of the act. Liability of e-commerce websites, Amazon, Flipkart, and others. Whether the mediation there is mandatory or not. Mediation is not mandatory. It is the Commercial Courts Act. There's now a provision in Companies Act also, which says mediation between the two companies. But under the Commercial Courts Act, now there's another loophole. Commercial Courts Act 2015 Section 12A says mediation is mandatory. This act says mediation is voluntary. Mediation Act 2023 says mediation is voluntary. Commercial Courts Act 2015 Section 12A says commercial suits. Before instituting a commercial suit, pre-institution mediation is mandatory. So this is a conflict. And there is a judgment of Justice Joseph, which has said it is mandatory in nature. Now, people are asking for urgent reliefs under the Commercial Courts Act to avoid mediation. Now, this is another, they have to make an amendment. They have to make an amendment before in the Commercial Courts Act. That is number one. Or otherwise in the Mediation Act. So these are some queries which you will have to introspect as law students. Because this is a clear conflict. Section 12A says shall. Mediation Act says may. May refer, may institute mediation. So you use the word may, but it originally used the word shall. It originally used the word shall and not may. Now it is using may, and the Commercial Courts Act is still using the word shall. So this is clearly a conflict. Whether an amendment is in the offing or only time will tell. But people have also found a loophole with regards to urgent relief. If a person does not want to go to mediation in Commercial Courts Act, under the Commercial Courts Act, he will ask for the court to grant him urgent relief. And the urgent relief, if he passes that test, if he convinces the court I have urgent relief to garner, then that section is not mandatory. Because you have this clear understanding from Section 12A that urgent relief has to be. So this was in 2018 that mediation, this Commercial Court rules, the rules under the Commercial Courts Act. So 2018 rules brought this provision. The rules talk about the Section 12A as well. That is under the Commercial Courts Act. So 2018 there was an amendment in the Commercial Courts Act. So to conclude, I've been told that I'm running short of time. So to conclude, mediation, we have to develop a mindset to sort issues which can be mediated in the country. And then mindset is important. Mediation Act is a step in the right direction. But the loopholes which I have discussed with you, those have to be addressed by the legislature. And then we will see less docket explosion and burgeoning of mediation in the country. I'll now be happy to answer your queries.
Thank you so much, sir. It was quite enriching. Sir, since you have already discussed the majority of the aspects of mediation, I would like to take your permission to present a few queries from our audience.
Yes.
So the first query, the first question that is being asked is, sir, sometimes mediation and conciliation are seen as correlative with each other. So having a separate Mediation Act and Arbitration and Conciliation Act, will it create ambiguity among the people, or is the provisions of the Mediation Act are very different from the existing Conciliation Act?
See, the Arbitration and Conciliation Act, that is the Act of 1996. And it talks about conciliation in a broader perspective. So as we already had a Conciliation Act of conciliation, so there's a conciliator. So that is different from arbitration. So conciliator will not pass an award. He has powers under the Arbitration Conciliation Act. So there is no ambiguity. Conciliator has the powers to has been asked, his role is defined under the Arbitration Conciliation Act of 1996. And in mediation, a mediator has been asked to perform a specific role. So there is no ambiguity. A conciliator's role is different with regard to the Arbitration Conciliation Act. Mediator's role is different with regard to the Mediation Act of 2023. So there is no ambiguity at all. If the legislature had brought conciliator's role in the Mediation Act, that would have created ambiguity, because there is already one act which is present with us. That is the Arbitration Conciliation Act. So there is no ambiguity at all.
Thank you, sir. So the next question is, mandating pre-litigation mediation can be problematic sometimes. So isn't it against the voluntary nature of opting mediation?
What is the query? What has she asked?
Like, isn't it against the voluntary nature of opting mediation?
No,
Making
now
it mandatory.
Now it is not mandatory. That is what I was telling in the starting. It was mandatory. The words used were shall. Now, that is why I asked the query whether it goes against the ethos of mediation, which is voluntary. Now the words used are may. So it is again, it is not mandatory. It is voluntary. Now that is why I asked them whether it should be voluntary or mandatory.
Thank you, sir. So the next question is, how can the practice of effective mediation be spread as a tool for dispute resolution among the masses? For instance, we see that in corporate areas, ADR, but not among us, the masses, right?
Yes, so that is why I said people as a whole have to develop this mindset, and we lawyers have a duty. Law students have a duty to tell the masses the benefits of mediation. Mediation Act has been passed. What is your benefit? So lawyers have a role to play. Law students have a role to play. They have to go to their respective places and towns and tell the people at large what are the benefits of mediation. That is why people will be able to effectively use mediation to settle their disputes. So this is a very good query.
Thank you, sir. I think all the other questions you have already covered in your session. In closing, we would like to express our heartfelt gratitude to you, sir, for graciously accepting our invitation and delivering an exceptionally informative session. We believe that the audience found it both engaging and enlightening. Your insights have truly enriched us, and we are grateful for the depth of knowledge you shared with us. I think the impact of your presentation will undoubtedly resonate with our audience for a long time. Thank you so much, sir. And we hope to continue this valuable association and eagerly await the chance to host you again. Thank you so much, sir. Thank you, everyone, for joining this session. And we'll meet you again with more informative and interesting sessions like these. Thank you so much, sir.
Thank you, Abhinav. Thank you so much. Thank you, Ayush. God bless you.
Thank you so much. Thank you so much,
Thank you,
sir,
sir.
for joining and enlightening with us such a wonderful session. It was completely a robust session on the mediation, as Mediation Act has been recently passed. So people were also waiting, and I myself, being an ADR enthusiast, want to learn about the Mediation Act specifically. So it was we are truly grateful to you. Thank you so much, sir, for giving your precious time.
Thank you so much. God bless.